Right. Hello. Thank you for joining us today. This is Welcome.us at the table, what welcomers should know about private sponsorship litigation. My name is Krista Kartzen, and I'm the Senior Director for Sponsorship Initiatives with Welcome.us. This event is hosted by Welcome.us, and we are a nonprofit, non-government organization founded in 2021 to equip and empower Americans to participate in the work of welcoming newcomers, primarily through private sponsorship. This is our monthly live webinar, which we call Welcome.us at the table. We've designed this space for sponsors and welcomers who care about private sponsorship pathways, the newcomers we've welcomed, and the stories of welcome that unite us. We have a special agenda for today, starting with Angela Bolins, whom you may already know from previous webinars or media engagement. Angela will tell us about her recent trip to Ukraine to see firsthand how the war has impacted the communities of the newcomers she sponsored. We'll then hear a brief policy update from our senior policy advisor, Manpreet Theji, followed by a conversation with Manpreet and our guest litigators from the Justice Action Center and the International Refugee Assistance Project, who are involved in current lawsuits affecting private sponsorship. We'll save some time for live Q&A, so if you have questions about the litigation process, please add them to the Zoom Q&A function at the bottom of your screen. You'll notice that the chat function is disabled, so if you have any questions, please do use the Q&A. We're not able to answer questions addressing a specific immigration case or the future of sponsorship programs broadly, but I know our guests will do their best to answer any litigation questions. Again, my name is Krista, and I'm a sponsor myself, which means I know how eager you are to get started. And it's my pleasure to introduce a sponsor who really needs no introduction at this point, Angela Bolins. Angela mobilized her community to welcome more than 20 Ukrainian families to Iowa and has truly been a champion for sponsorship. Angela, you just returned from Ukraine. Please tell us about your trip. What inspired you to go? What did you see? And how is the war affecting families?
Thanks so much for everything you guys are doing, and thanks for allowing me to share a little bit about our trip. So yeah, we wanted to go back and kind of circle all the way back around to the place from which a lot of our families came. We were starting to hear a lot of discussion within our community about how it may be safe to return and that these were temporary programs and it shouldn't be such a big deal. I think the idea in some people's minds is that the war has really tapered off and it's not such a scary place. And certainly Western Ukraine isn't too bad. So anyway, we didn't think that was probably the case, but we wanted to go and verify with our own eyes as nonpartisan, as not having any agenda, but we just wanted to go back and check it out and also bring some love to the families that were left behind. I guess, like you said, we have 76 or so people here in this area from Ukraine, most of whom came from the areas that were most harshly hit. So Kyiv and Irpin, some of those areas around the capital city, as well as on the eastern side of the country, Kharkiv and so forth. So yeah, we went through Poland and arrived in Ukraine, I think about March 21st-ish, I think, by the time we actually arrived. But we went with the International Red Cross and some people who were very well versed in how to stay safe while a war was ongoing. We went to the homes of some of the families that are now here in Iowa. And then we also went around to see firsthand some of the most recent damage. And just to understand what's going on and how is it affecting the families and the communities. And so it was very, very insightful. I will say there were a lot of moments of tears. It's just very difficult to walk through those spaces without just feeling it emotionally, because you know that this is where our families came from. But just in speaking and kind of answering the question of, is this a good place to return? It was very interesting because when we first arrived, the very first night in Kyiv, we made sure to stay in a hotel where there was a bomb shelter underneath the hotel. And of course, that very first night, and every night, by the way, bomb warnings or air alerts go off starting around 9 p.m. and they don't stop through the entire night. So that first night, we had our bag packed at the door with our essential documents and whatever, so that when those alarms went off or those raids happened, we could quickly go underground. And so we did. We ran underground and we sat there scared. I mean, it's just a very scary thing, but you can't sleep in those bomb shelters, right? It's just, they're not set up to where you can get any rest. So we'd wait for the alarm to end, and then we go back upstairs and try to get a little sleep. And about 30 minutes later, there's another alarm that goes off. And so you go back downstairs, and so we started doing the math statistically, and we're like, well, we're in a city of 300, 600,000 people. We'll probably be okay. We have to sleep, right? The trip alone was just exhausting. And so we returned, and I ended up opening up all my windows so I could hear really clearly how close the danger was. And we started to kind of live that way the rest of the time that we were in Ukraine. And that's where everyone is, right? I mean, they're trying to live their lives, but literally every night they are being terrorized by these drones that come in. And they're not killing hundreds of people at a time like the huge rockets that originally came, but it's just enough to terrorize people every single day they go to bed. They don't know if they're going to get up in the morning. These bombs come into the side, and they're now flying low enough that they come in under the radar often. They hit the side of a civilian apartments, right? Houses. I didn't see any recent damage to like infrastructure. And I don't doubt for a moment that they're hitting military installations, but we weren't close to those. But they're hitting apartments and houses and hospitals. And, and so people are just living in a constant state of sort of fear. And I made the observation when we were touring through it was actually, I don't know if it was on the news at the time, but there's a beautiful, beautiful zoo right about 8 miles from the Russian border. When we visited that space, it's still, you could hear the bombs or the gunfire in the background. That's how close we were to the front line. But, walking through the zoo and seeing how over 400 animals were murdered. And I made the observation that the people who I was talking to there had lost their employees. They were shooting animals just 2 weeks ago. So this is not in the past, right? And they didn't seem really very angry, and they weren't even bitter. And I was so angry, I could have just reached out. And I mean, I'm a very peaceful person, but I was just full of rage when I saw all this stuff that was going on. And then I started to realize that they're just completely numb. I mean, they are going, day by day, breathing in and out and just trying to get through the trauma. I spoke to another man in Kharkiv who actually runs a not-for-profit. His not-for-profit serves the children in Ukraine, and he currently has, through the U4U program, and they connected through welcome.us, I believe, his wife and 2 children are living in Virginia. And I asked him, I said, what do you think about families coming back? And he really did, I think, a really nice job of explaining why it's not safe for them to return. There's obviously still stuff going on, right? I mean, they're getting hit all the time. I'm sure you all saw in the news just in the last few days, quite a few deaths during daytime even. But he's currently treating children who are ages, 10, 11, 12, 13, 14. They wet their beds every night because of the ongoing trauma that they are exposed to. And he's like, even if the war should stop today, if those children return, they are immediately exposed to just really sadness and devastation everywhere. They're doing their best to repair the homes, but they're all still plywood windows and whatever. The money that's there that's being used to rebuild as quickly as possible is going into roads, hospitals, infrastructure. The houses aren't getting necessarily repaired. But anyway, he was telling me they would be exposed to all this trauma initially when they return. And the country is now accustomed to this idea that Putin says they're going to have peace, but they don't. It continues, every 18 months they're re-exposed to it, right? So basically everyone I spoke to, bottom line, felt that it was really would be a traumatic situation and not they would have a very difficult time returning to that country and living a normal life, even if the war was paused temporarily. So that, I guess that's kind of the big takeaway. It was beautiful to see the families that are members of the families that we have here. But yeah, I do apologize for, I do want to share with those that are online here. we got some heartbreaking news today. There's been some new announcements that I know our legal experts will talk with this group about, but we're hoping that one of our families that are scheduled to have to leave the country on May 22nd, we were hoping that one of these latest announcements would help them, and it turns out it won't. So we were hopeful, and we got some sort of sad news here just a few minutes ago. But when we were in Ukraine, we visited their family. We visited their parents. We visited the little puppy that they left behind. And they're in this little home that is just so beautiful on the inside. Their entire neighborhood is destroyed. You feel like you're going into a war zone, and their little house where this family's parents are, it's still intact. They had a lovely little dinner for us in there. But the idea that these folks are going to have to leave and return there it's really been a kind of a rough day for us here. So.
Angela, thank you for making the time for us in the midst of such a rough day and for sharing your story. That trip you took, you weren't just there for yourself and the families you sponsored. You were there representing hundreds of thousands of Ukrainians who fled those conditions. And you were representing every American sponsor who has gone through great personal lengths to serve as a bridge to safety. You've reminded us why it's still valuable to speak up for private sponsorship as a safe, legal, and orderly humanitarian pathway, even though it can feel like we're repeating ourselves over and over. It can feel lonely. It does for me at times. But every month at the table here in this space, I'm reminded that we're not individuals acting alone. We're truly a national community of welcomers. And Angela, as a leader in this community, your firsthand account of Ukraine so powerfully grounds the conversations we'll have just in a couple minutes about lawsuits and the human reality of the devastation that people have fled. So thank you so much for sharing your experience once again and for reminding us of the human impacts at the heart of our work. And of course, the human impact affects everyone who has sought safety here: Ukrainians, Cubans, Haitians, Nicaraguans, Venezuelans, and these are only the populations who were eligible for humanitarian parole sponsorship. You may be thinking of a specific person or family right now who isn't one from one of these countries, but whom you've sponsored or hope to sponsor. And you've joined today seeking clarity on their behalf. So I'm going to turn it over now to my colleague, Manpreet, to share some brief policy updates and lead our next conversation with the litigators. I've seen questions come through already in the Q&A function, so please keep those coming, and we'll try our best to respond if we can. Thank you, Manpreet.
Thank you, Krista. I will provide a quick overview of two key policy updates that have occurred in the last month. We have reviewed policy updates in more depth during our last webinar on March 20th. And for the sake of time, so that we can sufficiently hear from our guest speakers today, I'll only address sponsorship updates that have happened since then. As Angela shared, on April 4th, news outlets reported that some individuals sponsored through Uniting for Ukraine, or U4U, received an email from U.S. Customs and Border Protection at the Department of Homeland Security notifying them that their parole status will be terminated in 7 days and directing them to leave the country immediately. DHS stated that this message was sent in error to some Ukrainians who arrived through U4U, and that the department has sent retraction notices. It is unclear if DHS plans to issue this notice at a later date. We are following the matter closely and will share updates as they become available. In addition, recent reports suggest that termination of parole for beneficiaries who entered through U4U may soon be announced. At this time, we can't confirm an exact timing, but for that reason, we recommend sponsors and newcomers be ready and prepared. We do not anticipate a notice or grace period before the potential status termination. While DHS has made an announcement to terminate while DHS has not made an announcement to terminate humanitarian parole for U4U beneficiaries, on March 25th, DHS announced the termination of parole for individuals who arrived in the United States through processes for Cubans, Haitians, Nicaraguans, and Venezuelans, also known as CHNV. This termination was supposed to take effect on April 24th, 2025, 30 days after the official notice was published. Additionally, the Department of Homeland Security intended to prioritize removal proceedings for those who have not secured alternatives to legal status, such as temporary protected status or asylum, by March 25th. Being prioritized for removal does not mean these individuals will immediately or automatically be removed. Rather, they are prioritized above those who have already obtained an alternative legal status applied for by March 25th. With all of that said, on April 14th, a federal judge temporarily halted the termination of humanitarian parole for CHNV beneficiaries. This means that currently anyone who has entered the United States through CHNV has humanitarian parole status until the end date issued to them individually. So the DHS announcement terminating humanitarian parole effective on April 24th is not currently valid. But this could change rapidly as litigation progresses, even in the coming days. And we'll hear more about what this could look like with when our expert guests join us in just a bit. To help navigate these nuances and all the available resources, we developed a resource hub, which offers information and resources about what parole termination means, how to prepare, and what to do if parole is terminated. As you'll see on the screen, this hub includes tools to navigate termination notices, several Know Your Rights guides in case of an encounter with ICE, helpful FAQs, and a collection of other trusted resources. My colleague is dropping the link in the chat below, and I encourage anyone with questions about what I have shared so far to check this resource out. At this time, there are no new updates regarding the pause of US RAP, the termination of Welcome Corps, or the possible travel ban since our last Welcome.us at the Table webinar on March 13th. Please take a look at the recording or visit our policy page for more information. Now, it is an honor to welcome our special guests who are actually part of the litigation efforts supporting the continuation of both humanitarian parole status and refugee resettlement, the sponsorship pathways that bring us all here today. Please join me in welcoming Hillary Lee from the Justice Action Center, who is a litigator on the lawsuit challenging the termination of humanitarian parole programs, and Deepa Alagason from the International Refugee Assistance Project, who is a litigator on the lawsuit challenging the suspension of refugee processing. Our guests will help us understand the legal landscape, break down key objectives in their litigation, and provide insight in how these legal challenges may impact the future of private sponsorship. The purpose of our conversation today is to explore the impact that these lawsuits may have on private sponsorship, which is, as Krista put it, a safe, legal, and orderly pathway that allows Americans to come alongside newcomers who are seeking refuge in the United States. And with that, Hillary and Deepa, welcome to the table. Before we dive in, can you please introduce yourself and the lawsuits your organizations have brought in support of private sponsorship? Hillary, we can start with you.
Hi, everyone. My name is Hillary Lee, and I'm an attorney with Justice Action Center. We're an organization that harnesses the power of the courts to tell different stories about welcome and belonging. Jack and Human Rights First filed Svitlana Doe v. Nome in federal court to challenge the government's termination of humanitarian parole processes, including the CHNV processes for Cubans, Haitians, Nicaraguans, and Venezuelans. It also includes Uniting for Ukraine and others. In addition to the termination of the processes, we are challenging the government's decision to not process applications for asylum, TPS, and other immigration benefits that parolees have submitted. And finally, as you know, the government announced it would revoke parole status and work authorization for people here under CHNV. But on Monday of this week, as Manpreet shared, the judge in our case did temporarily block those revocations.
On to you, Deepa.
Hi, everyone. My name is Deepa Alagason, and I'm an attorney in the U.S. Litigation Department at the International Refugee Assistance Project, or IRAP. We represent a group of refugees, family members, sponsors, and resettlement agencies in a lawsuit challenging the suspension of the U.S. refugee admissions program and halting of funding for the program. The case is called Pasito versus Trump. Because the government suspended the entire refugee program, the case also involves refugees sponsored through Welcome Corps.
Thank you both for your introductions. Many of us have been following the news about these lawsuits, and there have been many terms used like claim, hearing, injunction, appeal, and compliance, which have frequently found their way into the media, but are rarely defined. Before we get into the detail of your cases, can each of you explain some of these terms? We can start with Hillary on claim.
Sure. Claim. In the context of a civil lawsuit, a claim is a particular demand or assertion made by a party to ask the court for damages or other relief. Within one lawsuit, there can be one or multiple claims that relate to different legal violations. Hearing. A hearing at its most basic level is a legal proceeding in court. During the hearing, both sides present evidence and arguments, and afterwards, the judge or jury makes a decision. Most often in the litigation we'll discuss today, it's a judge. Beyond those basics, a hearing can look many different ways. It can involve only oral advocacy by lawyers, or also the presenting of witnesses. It can address all sorts of topics as well, from very specific procedural or administrative requests to broader requests that address all or most of the arguments in the case. You might also hear people talk about going to trial in these cases, which is similar, but generally a trial is a longer, more formal proceeding that happens later in the case, closer to final resolution, where more extensive evidence is presented.
An injunction is a court order that stops someone from doing something or compels someone to do something. In urgent situations, the person filing the lawsuit can ask the judge for what's called a preliminary injunction at the beginning of a case to get relief sooner. If they succeed, the preliminary injunction stays in effect while the case moves on until the judge makes a different ruling at the end of the case. For example, in our case challenging the refugee ban, the judge issued an injunction saying that the government could not suspend the processing of refugee applications or letting refugees into the country. That injunction is still in place while we continue fighting the case. Appeal. Someone who loses a lawsuit can file an appeal, which asks a higher court to review the decision. Depending on the details, the higher court can agree with the original outcome, change or reverse it, or erase the original order and ask the judge to decide the case again with specific instructions. The end of a case is usually when someone is allowed to appeal, but there are some circumstances in which someone can appeal an order that they don't like in the middle of a case. Once a court orders a party to do something or to stop doing something, they have an obligation to follow the court's orders. We call that complying with the order, and the judge has the authority to take further action to ensure that parties comply with their orders. That's what we mean when you might hear about compliance.
Thank you both so much. That was extremely informative to our listeners. Based on that understanding, can you please explain what each of your lawsuits are challenging and what the current status of the case is? And Hillary, we can start with you.
Great, thank you. Svetlana Doe v. Nome is in the District Court of the District of Massachusetts, Boston Division, and our plaintiffs include people like many of you, humanitarian parole sponsors. Our clients also include Ukrainians who escaped the Russian invasion, Haitian newcomers who are fearful of being forcibly returned home, and other people who have been helped by sponsors like you. We also represent organizational plaintiff Haitian Bridge Alliance in this case. In terms of status of the case, last week we had 2 hearings in Boston where we asked the court to protect our clients and stop the following actions, or in other words, to issue a preliminary injunction blocking the following actions. 1, the federal government's attempt to end all existing grants of CHNB parole by April 24th. 2, the federal government's decision to stop processing immigration benefit requests for people here under parole, including asylum and TPS. And 3, any other attempts to terminate parole processes, specifically Uniting for Ukraine, Operation Allies Welcome, Central American Minors Parole, Family Reunification Parole, and Military Parole in place. We asked for a preliminary injunction, not just for our clients, but for everyone like them, by also requesting what's called class certification, which would ensure that any relief that the court orders will extend to individuals in similar situations nationwide. So on Monday of this week, what the judge did was the judge issued a stay or a temporary pause in favor of our plaintiffs and of CHNB parolees anywhere in the country. Specifically, she temporarily halted the government's premature revocations of CHNB parole. This means that for people who were granted parole under CHNB, their parole period will continue to be valid for the period of time that they were granted upon entry to the US. Their work authorization, if associated with that grant of parole, will also remain valid for that period of time. The judge also certified a class of all individuals who are still in the US on CHNB parole and were subject to the early revocation. So the CHNB parole termination notice is not only halted for the clients named in our lawsuit, but for all newcomers who arrived through CHNB. We are right now working very hard to make sure people who are directly impacted have the information they need on this update. So if you can, please do share the resource that will be linked in the chat with your CHNB beneficiary and sponsor networks. Please share widely. On the non-CHNB parole side, the judge has yet to issue an order on the termination of the other non-CHNB parole processes at issue in our case, like Uniting for Ukraine, or on the suspension of adjudication of immigration benefit requests for parolees. But we do hope she will soon. The only other very recent update there is that just a couple of hours ago, our judge ordered the government to tell the court about any other parole termination notices that have gone out en masse to parolees who entered through other humanitarian parole programs, like those that went out to the U4U parolees in error, as Manpreet was talking about earlier. Once we have an update, I do expect that we will share that on our social media or our website. So please do follow justiceactioncenter.org, also in the chat for that update.
Thank you so much, Hillary. And I know you mentioned your work relies on plaintiffs, many of whom are sponsors who are currently in the sponsorship process or who have already welcomed newcomers. We are incredibly grateful for the courage of those sponsors who are using their story to strengthen this case. Thank you for that. Deepa, on to you. Tell us about your litigation.
Hasido challenges the government's suspension of refugee processing and admissions and the defunding of the refugee program. Our plaintiffs include refugee applicants living overseas, their US-based family members, a Welcome Corps sponsor, and national and local resettlement agencies, HIAS, Church World Service, and Lutheran Community Services Northwest. The case was filed in federal district court in Seattle, where a couple of the organizations and individuals we represent are based. The judge in our case issued 2 preliminary injunctions, blocking the government from continuing to suspend and defund the program. The government appealed those orders to a higher court called the Ninth Circuit, and the appeal is still pending. The Ninth Circuit said that while the appeal is pending, the injunction can be enforced as applied to refugees who were already conditionally approved as of January 20th, 2025, which would include people who are trying to come in through Welcome Corps. What this means is that the government should be continuing to process the case of any refugee who was conditionally approved by January 20th. And once that refugee is done with the process, they can come to the United States. However, the federal government has not been complying with the injunction, so the pause to the refugee resettlement program largely remains in place. And of course, the order is paused for refugees who had not yet gotten to the stage of the process where they received conditional approval. The government, as I mentioned, has yet to implement the injunction in our case, So conditionally approved refugees are not arriving or having their cases processed at all. Last Friday, the district court told the government that they do in fact have to comply and ordered them to do so immediately, as well as to work with us to submit a schedule for coming into compliance. So we hope that refugee arrivals will resume soon. We don't have an answer for when that will be, but welcome.us will continue to share updates from our case.
Thank you both so much for the overview of the lawsuits your organizations are leading. Both of you have mentioned that a final resolution has not yet been made in these lawsuits. When can we potentially expect a final resolution from the judge? And specifically for Deepa, can you explain what the difference is between a preliminary injunction and a final resolution?
Sure. Parties can seek preliminary relief, like a preliminary injunction from a court, when they are experiencing irreparable harm, so harm that can't be repaired later on. A court will grant that relief if it determines that the party is likely to succeed on its claims and is experiencing a type of harm such that an injunction is needed now versus months or years from now in order to preserve the status quo. The idea there is that if the court doesn't do something now, there may not be effective relief available at the end of the case because of what happens in the interim. In our lawsuit, Pasito, it's hard to predict when the case might reach a final resolution because of the many moving pieces, including the pending appeals by the government and the possibility that the government may take some new different action. But the preliminary injunctions don't expire, so while they are in effect, the government must comply with them.
And for us, it is also very hard to predict when Svetlana Dovino might reach a final resolution because there are so many parole processes at issue, and also the government continues to take action around parole, so it continues to evolve. But in our case, the order issued by the judge on Monday was actually a stay, like I said earlier, not a preliminary injunction technically, but it still requires compliance from the government. And we're currently working to ensure that that happens. However, I also want to note that the government also has the ability to appeal the stay, which would mean that a higher court would reconsider the temporary relief and could potentially end it, which would then reinstate the original parole termination that we are trying to prevent. But if it goes up to the higher court, our team would continue to fight to make sure that that doesn't, or to try to make sure that that doesn't happen.
Thank you both for those answers. Hillary, how do you expect the US government to respond given the temporary stay related to humanitarian parole that was issued on April 14th?
Yeah, so we do expect the government to quickly appeal and ask the Court of Appeals to pause or reverse the stay while that appeal is proceeding. But as of today, they haven't done that. Beyond that, I can't really speculate about what the government will do. Our hope in all of this litigation and our storytelling efforts is that the government will recognize that people here under these processes are vital parts of our communities and the economy.
Thank you. And Deepa, at what point in the lawsuits are parties able to appeal the judge's decisions?
Appeals can happen at the end of a case, or in some limited circumstances in the middle of a case, as is happening in the Pasito lawsuit. Even if a district court's order is appealed, though, the order continues to be in effect until the higher court makes a determination about the appeal, and the party subject to the order is still required to comply. For that reason, parties, including the government, sometimes seek a stay or a pause of the order while they pursue an appeal. But unless the stay is granted or their appeal is successful, the district court's order stands and must be followed.
Thank you both. Before we move into a live Q&A, we have one final question. At welcome.us, we recognize and celebrate the power that storytelling has to transform communities. How does media coverage play into active litigation?
So Jack's entire approach is to use co-equal litigation and storytelling strategies. So to our team, communication strategy overall is just as important as the litigation itself. As part of that strategy, we always aim to uplift the voices of both welcomers and newcomers through media engagement, including social media, because those are the stories that really show the human impact of the government's actions and why the litigation matters, much like what Angela was sharing earlier. Stories also reach more people and can help shift the narrative around immigration. For example, our CHNV sponsor plaintiffs have written op-eds to share why they feel such a religious or moral conviction to welcome newcomers to their communities, and to highlight the hugely positive contributions that their beneficiaries have made, not only to their local communities, but to the sponsors' daily lives. For many, their beneficiaries have become like family. But the stories all of you can tell to family and friends, to folks in your parish or coworkers, those are even more important. We know that our communities are at their best when we're welcoming new folks, and the stories you can tell are so much more powerful than anything any lawyer can say.
We also see litigation as but one tool in a broader advocacy toolbox. So we are always looking to amplify public awareness about the issues facing our client populations, including refugees, through other means such as media coverage. Sharing stories about the care and community provided by sponsors provides an important perspective on what it means for the United States to continue to be a leader in welcoming people in need of safety, one that can combat other narratives that might get more airtime about the threat or burden that these populations impose. We would always rather have the public hear from our clients or others for whom refugee resettlement is a personal issue than the lawyers.
Thank you both, Deepa and Hillary. Now we're going to transition to about 15 minutes of question and answer. We've been receiving many of your questions in the Q&A function, and we'll try our best to answer as many as we can, either verbally or in the chat. We cannot answer questions related to a specific case, so we encourage you to seek legal counsel and check out our website for more information. To start off, Hillary, the first question is directed to you. Are all U4U sponsors included in any class action lawsuits at this time?
Thank you for this question. So while we have more than one U4U beneficiary as plaintiffs in our lawsuit, we don't have a plaintiff specifically who's a U4U sponsor, but based on the representation of the beneficiaries and the arguments we're making, we did ask the court to resume processing of U4U parole and reparole applications, which would obviously benefit both beneficiaries and sponsors. And we also, based on our requests, hope that anything the court grants on that would be nationwide as well. But in terms of your question about the class action lawsuits, I want to be clear that the court so far has only certified a class related to CHNV, the one I was discussing earlier. We are hoping for another order that will certify another class or multiple classes to allow more relief to be given. But that hasn't happened. And so if that does happen and we get more classes certified, we will be sharing that widely. So just again, please follow our social media and our website for updates there.
Thank you for that, Hillary. Deepa, the next question is directed to you. Many of our sponsors have been following the news about the State Department producing a report on refugee admissions. We wanted to know if you had any insight on if the State Department is still planning to produce the report about refugee admissions and resettlement on April 20th, and if so, what can we expect out of that?
The executive order that suspended the refugee program, it called for a report about the refugee program to be submitted to the president within 90 days. It's unclear whether that report will be made to the public. Certainly in the context of other executive orders, there have been reviews called for and reports called for that were not shared publicly. It may be that through other lawsuits, through FOIA, people try to obtain it and it may get disclosed at a later time. But right now, it's unclear that that will be made public and, of course, unclear what the contents will be.
Thank you so much, Deepa. And actually, the next question is also directed to you. We've been getting quite a few questions about this. Some folks have seen media reports that the US government will resettle refugees from South Africa. Is that true? And does that mean refugee resettlement has resumed?
There has been public reporting about this and about a new operation to resettle people from South Africa. Despite the creation of this program and people coming in through that pathway, the government has been clear to applicants, as many of you may know, that they had continued to be suspending the processing of US RAP applicants. So it remains to be seen how that fits in with the broader refugee resettlement scheme. As I mentioned earlier, though, the judge in our case has made it clear to the government that they are required to resume refugee processing for people who were conditionally approved as of January 20th. So there should be some information filed with the court soon about the timeline for getting that restarted again.
And Deepa, I know that we're getting a lot of questions about Welcome Corps, so apologies for putting you in the hot seat right now. We wanted to see, could you clarify what you meant by conditionally approved? And does that mean that their Welcome Corps application was certified?
So conditional approval is something that a stage that happens for all refugee applicants, regardless of whether their application came in through Welcome Corps or some other access pathway. When it typically happens is after a USCIS interview, USCIS will grant conditional approval and often send the applicant what's called a notice of eligibility that tells them that they are conditionally approved for resettlement to the United States, pending medical checks and additional processing before they can travel. So it happens, somewhat midway through the process after USCIS has deemed them to be conditionally approved.
Thank you. Hillary, back to you. We got a question about sending families back, which is, can sending a family back to a war zone be used as a valid reason for causing irreparable harm?
Okay, thanks. I think this question is relating to what Deepa was saying about for a preliminary injunction, you have to show that there's irreparable injury or irreparable harm. And what I can say is that to us and our plaintiffs, it is certainly considered irreparable harm to be sending someone back to danger, including to a war zone. And in our motions for preliminary injunction, we made that argument clearly, both when it comes to Ukrainians, and we also talked about how it's irreparable harm to send folks, for example, from Haiti back to places where they might fear violence or other things. And so we made that argument, but the way that it works in the court, which I was talking about in my definition of hearing, is that we make the arguments and then the government makes their arguments about how they don't think it's irreparable harm, for example, and then the judge decides. And we don't know exactly how the judge will weigh these things yet when it comes to the U4U program, because we don't have a ruling on that yet. But for example, in the CHNB context, we know now that the judge agrees that there's some sort of irreparable harm. Even if she didn't issue technically a preliminary injunction, she did assess that and ask us a lot of questions about that at the hearing.
Thank you so much. Back to you, Deepa. We're getting a lot of incoming on Welcome Corps. Wanted to ask, what's the case for Welcome Corps? What's the case for Welcome Corps cases that have just started to be contacted by overseas agencies, but they didn't do an interview? How could this injunction apply to such cases?
It's hard to tell without knowing the details and based on this, but further to what I said before, typically conditional approval is issued after an interview. So if there is a case that hasn't been interviewed and hasn't been notified that they are conditionally approved, then the court's order is paused for that group, which means that the government is not required to process those applications. So anything that happens in terms of the refugee program restarting right now is going to happen only for people who did receive that conditional approval, and not for people who are earlier in the process. Of
Okay.
course, that's the state right now. That could change in the future.
No, that's very helpful to hear. Um, and so just to clarify, what would it mean for Welcome Corps applications that were completed but are waiting for travel schedule only?
I think similarly, it's hard to know what's meant by whether the application was completed, but if they had been approved by USCIS and done all the required checks and are ready for travel, then our hope is that soon, once the judge enters this compliance schedule, that travel will start to be scheduled again, but we don't know when that will happen.
Thank you. Both of you talked about the impact of storytelling. Hillary, this directed to you. Do you recommend articles in the local newspaper supporting Ukrainian families? And if that family could possibly be identified? A sponsor said that their paper demands their name and that they only have one family. Could they be could they be targeted by the government?
Thank you for that question. I think that's really great question to discuss. I think it's nuanced. I can't really advise you what to do, but I think my answer is that it depends, and it's a really like an individualized decision based on how you and your family feel. We have had sponsors, for example, give their name but not their beneficiary's name. But in those cases, oftentimes they have more than one family that they're hosting. And so, to the point that you only have one and you feel like it might be easy to identify them, um, I think that comes down to whether you think your local community or the state or wherever you would be publishing this article would receive it well, or whether there could be any risk of retaliation. Because the reality is that we have seen some backlash, both online, from community, from there's also a fear of potential retaliation from the government in some cases. And this is something that we discuss with our plaintiffs when they sign up to be plaintiffs, as well as with our spokespeople when they tell stories in the media. And so I think at the bottom line is it's really a case by case decision, and it can only be made by you and your beneficiary about how safe you feel. But there are options in some cases to be more anonymous. Maybe this local newspaper doesn't let you do that, but maybe some other platforms would.
Thank you. And Hillary, right back to you. If a Ukrainian's parole ends, but they still have a pending reparole and they have TPS, can they stay and work?
So I think I'm gonna only answer this from the perspective, like more generally. I can't really advise specifically on what folks should do in their individual situation. But if the question is that they have pending TPS and pending reparole, that's different from if they have pending reparole, but they have TPS. But essentially, at the end of the day, it really comes down to whether they have work authorization that's tied to just their parole grant, or they also have TPS and they can get work authorization under TPS, or have work authorization under TPS. I think the complication, though, is that right now the government is not adjudicating applications for reparole, TPS, or work authorization for people who came under parole. And so unless they already have work authorization that's not tied directly to their parole that's ending, we don't know when those applications will be looked at. And so that puts people, I think, in a precarious situation in terms of whether to stay and work with or without authorization. And so that is also part of our lawsuit, as I was describing earlier. So we're hopeful that we can get some relief to change that.
Thank you. I know we only have 2 minutes left, so we'll try to get one, maybe two questions. And Deepa, directing this question to you, how are some refugees still arriving in the U.S. if the U.S. route program has been suspended? Is the SIV program being used? Would love to know if you knew more about that.
Sure. Of course, the suspension is one that was instituted by the government. They still retain the control to allow whomever they choose to come in. And so despite the fact that they have at large suspended the program, we've certainly heard of cases of individuals coming in, including the potential refugees from South Africa mentioned earlier. The SIV program is still operating, and people are able to come in through that route. For a short period of time, the government was again admitting follow to join refugees who are come in through a different pathway for close family members of refugees who have already resettled in the United States. So there are, small numbers of people who are coming in through different pathways. But of course, we hope that through this lawsuit, the doors will open more widely so that people can start coming in again.
Well, thank you both so much for your helpful answers today in the live Q&A. Hillary and Deepa, thank you both for joining us today. Truly, I've learned so much from you, and I know many others have, and I'm so grateful you took the time out of your very busy schedules to share your expertise here today. If you were inspired by anything Angela, Hillary, or Deepa shared today, we encourage you to consider taking a couple next steps. For you, that may mean contacting your representatives to let them know just how meaningful sponsorship has been to you. If that's the case, take a look at our resources in the chat and use the form and draft messaging to send an email or give them a call. It may also mean sending a quick email to stories@welcome.us to schedule a 15-minute storytelling consultation meeting where our storytelling team will go over your outreach goals, your experience, and offer resources to help you craft and share your story. If you're looking for more inspiration, our guide to supporting sponsorship, linked in the chat, offers some ideas depending on how much time you have. Finally, you can share the stories we've already told by voting for us in the Webby Awards. Welcome.us's video series, These Stories of Welcome, have been nominated for a Webby Award, the leading international award honoring excellence on the internet. Our series highlight your story, stories of Americans coming together to build a movement of welcome. You can share the word about the important work of welcome that Americans are doing across the country by voting today, which is the last day to vote. We are dropping a link in the chat below. And of course, I hope you will join us for the next Welcome.us at the Table event on Thursday, May 15th at 3 p.m. You can register by clicking the link in the chat, and the link will also be included in an email you'll receive tomorrow morning, along with some of the resources we've shared today. We'll close in just a few seconds, but before we do, we ask that you respond to the short survey that will pop up on your screen once the webinar ends. Your feedback helps us remain responsive and relevant to your work of welcoming, and it is your work that inspires us every single day. After you complete that survey, the time is yours. Take the next couple minutes to vote for the Webby Award, to book a storytelling consultation, or to contact your representatives. And of course, join us again here at the table on May 15th. Until then, thank you and be well.